Um, all right, let's let's start with yes, our Tuesday. Hello everyone. Welcome, 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 welcome. Nice to see you. Well, the ones who are without cameras also would be happy to see your faces meanwhile. And yes, well, unfortunately, I was already telling to Vasily that I don't have any Santa cap because today is the last workshop of the year, and it could be some kind of a Christmas party at the same time. Even though that could be a little bit wicked, discussing IP and legal questions, being in Christmas dress code, but. We never know. We never know. All right. So I hope that you all can see me and can hear me. And you're also excited to be here to kind of finish it all up for 2025 and plan for 2026 ahead. So I am, okay, sorry, I'm constantly admitting people in. So that's good to see that Tuesday is very productive day. And today we will speak about, so there is a week, right, that we have IP and legal. And we had during batch one really nice session with Katja Fischer on just legal fundamentals. We decided why to repeat ourselves. And that's why our personal recommendations is to go and check the recording. And we were not touching that much the IP part, but also the IP part just for the sake of the IP is also rather boring, especially for, come on, 16th of December. So today we will have IP from the angle, from the perspective of the investors and stakeholders. So we have a really, um, I would say, a special dish with a special sauce presented by Vasily here. And without further ado, Vasily, let's get it going because I think that no one can make a better intro of themselves as the speakers themselves.
Oh,
So yeah, passing the baton to you, and yeah, you see already people putting the thumbs up.
yeah, amazing. Irina, thank you for the introduction. So let me say just a couple of words about myself. I'm a legal practitioner, so I run my legal practice for startups and funds in Abu Dhabi. So I used to work for a number of venture capital funds based in Russia with investments predominantly in United States, in the European Union, and I would be glad to share some of the practical bits from my experience, something that I hope would be of use for you in your company development. So I have prepared a number of slides for today. So if you don't mind me, I'll can I share it, right?
Perfect. Yeah.
I
Mhm.
mean, I can share the document, right? So I'm entitled to do it.
Yes,
Give me a
you are
second.
gladly
Tell me
invited.
if you can
Yep.
see my page. I'm sorry, this.
Hmm.
So let's start from the very beginning. So as I named it IP Essentials for Founders.
You
So this,
you can click the down there. There is like a slideshow um, tag. So where there is the
yeah,
scale. Yeah.
I got you. Yes, 1 second. I think this one, right? No?
Yeah. I think so. Let's see.
Yep,
Oh,
perfect. Yeah, that's the one.
yeah. Hmm.
So basically, the idea is not to present too many details related to legal doctrine or tell you all sorts of complex legal ideas and concepts, but focus mostly on what the investors are expecting from you as a startup when you are undergoing the diligence process or when you are discussing the investment details with your investor. Uh, so basically, these slides are based on actual experience, and where appropriate, I decided to, either cite some personal experience or relate to some widely reported news or let's say scandals or occurrences that happened in the um, tech market, VC market in recent years, recent decade. And also, I need to note that I tried to make it as applicable as possible for founders of AI startups. So not just a startup, but with a focus on artificial intelligence. So I suggest we start. So this is the initial slide. So let's go further on. One sec. So yeah. So why are we talking about IP? So key thing in this respect is that intellectual property is the main thing that investor is looking in a company. So obviously, in order to start conversation, you need to focus on your traction, revenues, etc. But as soon as you are on the radar of the investor, sooner or later, and I guess sooner, you will need to actually show what you have as your intellectual property assets. And in essence, if you are a, let's say, seed stage startup or pre-seed stage startup, in essence, these technologies formalized as intellectual property, they are all you have at this point in time. So obviously, the investor's expectation is that of clarity and certainty of ownership. And what is good for you is that at this point in time, when your company is like at your first, second year of existence, or maybe even third year of existence, we look at, or let's say myself as a in-house counsel, we look at IP not as as something that presents certain legal challenge or presents some problems from a legal perspective, but we look at it mostly as a risk management tool. So basically making sure that your company is the sole owner of IP, and also that your company and you as a key founder or sole founder of a company has taken all measures to ensure that nobody else but company holds all intellectual property to a specific solution. And also what is good for you is that at this point in time, when you are at a fairly early stage, these matters like IP ownership problems or aspects can easily be settled by signing some fairly straightforward documents as like IP assignments between founders, IP assignments between contractors and the company, as opposed to later stages when somebody comes up and says that this specific person has contributed to IP creation back when the company was launched. And at that point in time, the problems will be, critical. They potentially could risk the further development of the company at a specific point in time, let's say in 4 or 5 years after the company was launched and started showing some measurable success. And probably more on a psychological side, existence of registered intellectual property or let's say specific attention paid by the founder to the intellectual property matters shows that this person is disciplined and, well, let me say trustworthy in the eyes of investor team. So as I mentioned here, evidence of founder's maturity, like somebody is a seasoned entrepreneur and understands that each aspect of the company's activity is important. So we go to the next slide, so as I mentioned initially, I'm using this concept of investability. So basically, this company is good enough from a legal standpoint to be an investment target. So somebody is eager to, let's say, form a joint venture or invest in a company and become a majority shareholder, let's say preferred shareholder, etc. So what do I mean under that? So what are the aspects or components of investability? And here I mentioned probably the first most important thing, which is exclusivity of ownership. So investors would expect that the company controls every single aspect of intellectual property that it needs to practice, to exercise, to basically implement and offer the product it has created. So it means that there are no um, third-party contractors who at some point in time did something for you, received their consideration, and vanished in some direction. And you lost track of these people and can hardly access them, let's say in future, once you are asked, and who are the contributors. As well, what is important is transparency of contribution. So basically, you need to understand what every specific person or a group of people, contractors or employees or let's say co-founders, what they contributed to the product as a whole. I mean, even though that may sound self-evident, of course, very often, and I mean probably more often than I would expect, these questions are left untouched or are left uncovered by founders. And sometimes, let's say you have a M&A deal, somebody acquires your company and gives you time to fix these issues. And at that moment in time, when you have to ensure that the company controls every single aspect of intellectual property, it turns out that you can't reach these people who used to be your subcontractors like a while ago. And the problem is that their negotiation leverage against your company and yourself is very, very large. So, I mean, it's not unlimited, but look, in future, you will have a lot of tension with them because there is a high likelihood that they will ask for compensation for assignment of those rights. And this is probably would be a good, not a good, but a bad surprise for you moving on and at some point in future. Another aspect of investability is that your intellectual property has to be easily scalable. And this is, here I'm touching a different aspect, a different domain. Here I'm talking mostly about your relations with key customers. What I mean exactly? It means that once you are negotiating major, let's say, licensing agreements with your customers, or let's say master service agreements with your customers, they might want to insist on various limitations in order to ensure that they are the only ones that are using your product and they're the only ones that gain exclusive advantage provided or ensured by your product. Well, that may be, let's say, geographic limitations, like you work exclusively with us in the territory of United Arab Emirates or United Kingdom or elsewhere. It is very important to understand and to keep track of all possible limitations that you agree to with your customers, because inevitably at some point in time, let's say after you have raised funds, there will be roadblocks for your expansion, let's say in other markets, or let's say in your market where you started. Also, pay attention to what is the agreed use of your product, and make sure that, let's say, if your customer decides to change the use of the product, so you can easily, let's say, react to it and make necessary amendments. Here I made this is exactly the element of real life experience. That's a actual story that happened around 7 or 8 years ago when we had to negotiate a joint venture with one entrepreneur who was building an exchange, like a platform for offering financial instruments. And he specifically mentioned that he has software, a computer program registered in his name. And in no event will he disclose the code on one side, and in no event will he contribute the source code to the joint venture company. And we had a lot of negotiations, so we had to do all sorts of risk assessment. And at some point in time, we decided to go to actually execute this deal. And for about, let's say, one and a half, 2 years time, we achieved big results. But eventually, when the relations went, they were not as good as they once were. The first, or let's say one of the first arguments the founder had was that, and not forget that I'm licensing the software to you, and our agreement provides for my right to claim early termination of the license agreement. And that potentially, allegedly, may put end to offering these platform services to third parties. And obviously, we had to negotiate around it and provide compensation to this co-founder. Even though we knew in advance that that would be risky, we went for it. We went for this, standalone software registered in the name of the natural person who we're dealing with, but that was seen as an exception to an overall rule. Another experience, not from my, another example, not from my experience, but it's very close to where I'm working, is that some of the clients actually agree upon exclusivity in a specific market. And interestingly enough, many customers, let's say in UAE, they would expect to be the sole pilot. So they would expect to be the sole users of a pilot device specifically for them, and quite often, in the eyes of the investor, that may be seen not only as an advantage. Like, let's say we work with the biggest telecom provider in Arabian Peninsula, but also it can be seen as a problem because you won't be able to implement your solution to anyone in the same domain where this telecom operator functions. And that may be seen as a, let's say, it's like a double-edged sword. So it can be an advantage, but also it can present there could be problems associated with this. So what are we talking about when I mention intellectual property? And let me also stress what is more important and what is, let's say, auxiliary. So obviously, source code is the key element of intellectual property. This is probably something that, goes without saying. So this is the first and most important part of it. So basically, the question that the investors might ask relates to the team of authors. So are we sure that everybody is mentioned, everybody has executed the IP assignment agreement? Has anybody released all the potential claims they had in relation to this? So are we good to go with this software in future? So the other thing is the other IP component, and it is like close to source code, but it's like a bigger element. And I'm talking about the models and improvements to them that are practiced by your company. And here it is it's a different side of this problem, because we're talking about how does your company work with its clients. So how do you allocate who owns the intellectual property deriving from the use of your products? And most importantly, in many cases, there is such concept as improvement. And if a specific, let's say, code or model is significantly improved and does not bear likelihood or material likelihood to the original model, then potentially it may be seen as a separate, as a newly formed intellectual property object. And obviously, since it has been created, the question is who owns it. And sometimes it is important to pay attention to clauses on improvements. And it's not unheard of that big clients eventually got the rights to improvements. And it's not that they stripped the founders of their rights to what the founders initially created, but there definitely is a conflict at some point in time in future once the cooperation has been ongoing for, let's say, a year or two. So next item, which is important to remember, obviously, and I dare to say it's the most important one, is know-how. So basically, this is the something that gains its value from not being publicly known. So this is, in essence, the way your whole system operates. So all the nodes, all the components, how they're put together to ensure that a specific result is achieved. So basically, well, technical documentation, of course, yes, but what is essential here is that it's important to understand that on the one hand, this information stays confidential and nobody has access to it. On the other hand, it is important that this information is shared not only by between founders, but also shared with some technical personnel that is under confidentiality undertakings, right? Because imagine what may happen if a founder goes, or say, forms a new startup in an adjacent sphere. So what happens next? Does it mean that the know-how is lost? He took all the files, he took the product maps, etc. So what happens next? Is it so? So there are two aspects of it. Can a specific third party access it, from the outside? And the other aspect is, can your employees have access to this documentation? So these are the questions that the investor may have in mind. So as far as brand names, trademarks are concerned, this is all fairly straightforward because this relates to opportunity to go abroad and to advertise yourself with like using the same brand name as in your original country. But I guess that's more or less self-explanatory. And another thing that I had to note, and I mentioned it on a previous slide, is are there any limitations on what the company can do with its key asset? And I'm once again referring to the contracts with your key customers, where you may agree to specific limitations, and you have to understand that your development program in future will be influenced by those concessions you've done in past. So I move to the next slide, which is more of a technical nature. So we are discussing the ways to, or let's say the lines of relations that would matter to an investor. And here we're talking about relations between company and its employees, company and its contractors, and relations between co-founders and the company. And here it's important to note that these three lines of relations, each they are governed separately. So let's say when we're talking about relations with employees, we mean that there are employment laws that would govern the allocation of rights to intellectual property. And rule of thumb all over the world is that since anything was formed as part of employment relations, the employer, that is the company, will own intellectual property rights to the product of the work of employee. Having said that, there are many country-specific rules and requirements and I will mention these when I will discuss one of the cases from the real world. In case of contractors, this situation is more, it needs more attention on the company side, because anything the contractor does to a company automatically belongs to the contractor unless the parties agree otherwise. And this is something that you should always bear in mind, that you have had excellent cooperation with a specific third party specialist, some software developer from, let's say, Eastern Europe. He was giving you great job all this time, regardless of any, circumstances. And at some point, you said bye to him, and he left. So that is a very risky situation, because in the absence of any arrangements or agreements signed between your company and this contractor, he will have a right of claim against your company in relation to those bits of intellectual property he helped create. Well, let's say software code. And the risks that the company may face when it happens, I wouldn't say they are immeasurable, but definitely they are quite significant. And in real world, that may expose your company to very significant expenses on settling these claims by contractors. I mean, that's obviously if they are willing to go after your company, if they understand the extent to which they can claim compensation. Because in the worst case scenario, they may even file for, let's say, injunction, which would mean that your company will be prevented from using the product it offers to the market. I mean, it can go as far as this in the worst case scenario. Likewise, when we're talking about co-founders at the stage when the company is just formed, it is also quite important to have this internal discussion and see and to decide what kind of contributions the co-founders have to make at the start of the business. Because sometimes you just go in this venture together, you form a company, everyone gets its, let's say, 50 or 33%, or you name it, 25% share, and then you move on forward. But having said that, the mostly, I'm talking about software, obviously, the contribution brought, like informally brought by a co-founder, still stays as his property. Basically, it belongs to him, and it's important from the very beginning to make sure that he signs all the paperwork to make sure that his rights to a specific IP object go to the company. So obviously there are many ways to address the situation. So here I'm mentioning the so-called retroactive assignment. Let's say this issue emerged 2 years after the company was formed, and you are, let's say, trying to address those things that should have happened a year ago, 2 years ago. So for these purposes, this instrument would be appropriate. Likewise, release of claims by third parties. So this is something that the investor may ask you if the investor is about to make an investment and you're given some grace period, let's say 1 month, 2 months, 3 months, to make sure everyone executes this release of claims documents, to make sure that they won't sue you as your company grows. So there are 2 stories, fairly widely reported, especially for those who are familiar with Russian tech ecosystem. So Rambler versus Nginx. So this is I would say, comic story, mostly a comic story, but unfortunately it took place in real life. So what happened was the founder of Nginx was employed by Rambler in early 2000s. And during the term of his employment, he was devising the early concepts, the prototypes that would form part of Nginx solution. So he was developing this company for at least, say, 7, 8 years, maybe 9 years. And it grew big enough to become a target company. And it was acquired by Palo Alto Networks in 2016 or nearby, like mid 2010s. So you can see more than 12 or 14 years has passed since he devised this idea while being employed. And at some point in late 2010s, like in 2019, Rambler, and it was already a few years after Nginx was acquired, filed a suit against Nginx and against Palo Alto Networks, asking for compensation because allegedly the rights to the solution practiced by Nginx belonged to Rambler because they were employing Nginx founder. And it took a lot of efforts on Nginx side to prove their right, to prove that Rambler doesn't have any rights to the code. But the decisive argument was that Rambler were sitting for too long to claim their rights, and there was a litigation in United States courts, and the court said that we would have contemplated your arguments, but problem is that you've waited for more than 10 years to file your claim, so that's why we won't let you win. So the claim was dismissed. But having said that, this was a very significant case, and it was a very good illustration, very illustrative case to understand how important it is to have proper paperwork in place. The other one is Waymo versus Uber. This is obviously the US market, and it's more widely reported than the previous case. And here what was interesting is that if I'm not mistaken, the Waymo founder left Google to establish his startup, which was later acquired by Uber. And when leaving, he took all sorts of documentation, some files with confidential information related to driverless cars and the way they operate, the way the algorithms operate. And Google and Waymo decided to go after him and sue him for trade secrets theft. And eventually they had to settle out of court. And obviously the founder so that the person, he was found liable, and because he was under confidentiality undertaking. So he had to settle, but otherwise he would have been found liable and the fine would have been even bigger. So let's move on further on. So this is the slide related to artificial intelligence and how the concept of investability applies to them. So as mentioned previously, I'm paying extra attention to how the rights towards outputs are allocated, because like in the absence of a contract, what happens is you are giving somebody a right to use your software, and the results of use, they, by virtue of law, they belong to the company that has devised the algorithms and the AI solutions that helped produce these outputs. And that's why most of licensing agreements or master service agreements related to AI solutions, they would have in one way or another a clause that would give right to customers to use the outputs. But quite often, this right to use outputs can be extended to relate to improvements made to models, and this is something I mentioned a couple of slides ago. And eventually, the big risk is that as a result of such clauses that grant rights to improvements to your customers, the development of the product may be severely impaired, limited, because you would have some third parties, I mean clients, who will have some rights, residual rights to your product. So here I mentioned, so what to bear in mind, so recommendations. So basically keep track of what you agree to with your customers. So obviously, ideally, if you have a template licensing agreement and you use it with every client of yours, that's easy and that's good for you. If you offer bespoke AI solutions to big customers, and I mean, by saying so, I assume they would have something they created themselves, some legal document they created themselves. It is important to understand where exactly they try to protect their rights and potentially take rights away from you to the extent possible. So this is important. I mean, at some point, your expansion plans in a specific jurisdiction or in a specific area might conflict with what's written in your agreement. So I'm not saying this is 100% guaranteed, but it's important to keep track of it. So another item is exclusivity or non-exclusivity. I think that's more or less self-explanatory. So basically, your freedom to conduct business with any third party in a specific allocation. And as I mentioned, leakage of rights, and that's exactly what I was referring to in rights to improvements to models. So your rights start to leak as soon as a result of cooperation with a specific party. You start improving, but it's not entirely clear who gets the rights to these improvements. So let's move on further. So I want to touch base trade secrets and know-how, which is the key element of your company's IP. So ideally, let's say dozens of years ago, maybe 50, maybe 100 years ago, one would have thought that, why aren't we talking about patents, which is the most obvious way to protect your intellectual property and the strongest protection against third-party claims. Moreover, it gives you probably the biggest leverage against your competitors in the market. So problem, however, is that patents are definitely not the solution for 21st century, 2025, because in order to procure a patent issue, it takes at least 4 or 5 years. And the problem is that the patenting field is so saturated with all sorts of patent applications filed by small market players, big market players, that it's virtually impossible to claim a specific solution or patented algorithm, or let's say hardware object that would be wide enough for you to make your competitors leave the market. So basically, patents no longer fulfill their purpose as they used to, let's say, 50, 70 years ago. And right now they're seen more as basically papers, like some kind of paperwork that is worth something and that may potentially increase the value of your startup, but it won't give you any meaningful protection as you move on further. And
But
on the
here,
contrary,
if I can also kind of address the question, we have also deep tech companies, like I mean deep tech with regards to some proprietary technology. So I'm very curious to hear like and also to probably oppose. Maybe we will actually ask the audience who is today from Deep Tech, for example, to yeah, tell just one liner what you do to Vasily, and also say why do you choose patents? Because I know lots of teams are still thinking about filing one,
Mhm, mhm.
or maybe not, maybe already not. I don't know. So it's just that, kind of I would say the interaction right now really needed. Let me see who is with us today. Um, yeah, for example, Cell Kinetica. What do you think about what Vasily said?
Yes. Hello, can you hear me?
Yes,
Yeah.
Yes.
absolutely.
Okay, nice. Thank you. And we are Cell Kinetica, so we try to improve in vitro fertilization success rate by genome-based analysis of embryos. And so we provide some biomarker which will rank embryos as an order of transfer. That's our product, like ranking of embryos, first, second, third. And for now, we have we discussed a lot patent issues. It started from little problems that I was at this moment at École Polytechnique Fédérale Lausanne, and they wanted to take part of patent, but finally my big administrators in this EPFL, they told me that, okay, you are free, that's completely your product. So we were thinking to get patent for company, but after long discussions, we realized that we have to make patent as soon as possible. So now we at proceed stage. So we try to find new big clinics to get more data, to tune our product, to tune our software, and to make patent maybe in 18 months, maybe in 1 year and a half. Because first, we don't want to be visible. Let's say our trade secret and know-how is much more secure when it's, let's say, in our supercomputer. And we just don't want to describe algorithm. So it's very naive, very simple, because
But
our algorithm is so that's why we also don't want to write scientific papers. We have one, but we keep it as secret, as NDA, so we can show it to some other investors if they want. So our strategy is very simple: to do patenting as soon as possible, and go with trade secret, go with paper which we keep in pocket, and we show to some bigger potential customers. So that's our strategy.
interesting, interesting. So thing is with patents is that, um, I mean, these days it is seen as a protection, not as a tool to wipe out the market. Like come to a competitor and say, "Here is my patent. I'm the only one who is eligible to practice a specific solution or a specific technology." It works in another manner. Let's imagine some company comes to you at the doorsteps and tells you, "Well, look, we work in the same field. Basically, we are your competitor, and you are infringing our patent." And in response, you take this paper and says, "Well, could be, but look what we have." And let's say I'm 95% certain or 99% certain that you are violating our patent. And in essence, these days, instead of granting you the leverage it used to give like many years ago, patent turned into this like a tool, like a protection tool, but its role has changed dramatically in the last decades, unfortunately. And oh, maybe fortunately, I don't know, but I don't see it aside from very limited areas of modern technology, and I'm talking about chemistry, pharmaceuticals, manufacturing, maybe consumer goods. But other than these areas, let's say, well, maybe medicine, but medicine is a little bit different. So other than these areas, patents become, there's a tendency for them to become worthless. Like they don't cost much. So it takes like 2-3 years to procure one, or actually more, 4 years to procure one. And then let's in the worst case scenario, the company is going bankrupt for some reason, once you try to sell it to somebody, to a third-party acquirer, they are sold for like, I don't know, maybe $1,000, maybe $10,000, which is, nowhere near the price of efforts invested in its creation. So that would be my, subjective reply. But I totally respect the like your choice in favor of going for patent, just to be sure that your big clients will appreciate the fact that you went the conservative way. And with passage of time, let's say 5-7 years after your company is formed, obviously having a portfolio of patents adds credibility. I mean, yeah, that's correct. However, that doesn't really protect you in the market. So it's more of a legacy. It's like, going for a competition, let's say, in your specific area and winning it. Like, let's say, hackathon. You are number one. You've been named number one for this, and this. So it gives you recognition, but does it really help you conduct business? Maybe not so much. So yeah, turning to trade secrets. So basically these days, this is the main area where companies, especially startups that practice their AI solutions, would normally be concentrating their efforts. And I'm talking about making sure that the information, such as, product logic or processes used in AI workflows, they are kept confidential, and nobody could potentially disclose it to third parties. Also, obviously, internal control should be put in place. Ideally, you need to have something like confidentiality policy inside your company to make sure that all the sensitive data is kept, on a specific server with some limited access to it, only for senior officials. I mean, it will definitely help, especially if some rogue employee will try accessing it, or let's say will go and form their own startup. But that's how that will give you a legal right to go after him or her and sue for damages, or let's say file for infringement and prevent him from further activities. So the role of trade secrets and know-how has expanded significantly, and I think these days it's probably the most useful tool. And as a confirmation of that, basically note that in the United States there is a criminal legislation that penalizes disclosure of trade secrets, and a person may even serve in prison for espionage, for taking out trade secrets and disclosing them. It's that important. So I'm moving towards like the last parts of my presentation, and here I'm talking about structuring considerations as to where to keep the IP. So basically, if you are, it's obviously easy if you have only one company and this company operates globally, so you have clients in various countries, and the counterparty is only one. Like your company is the sole potential counterparty. But imagine you operate across a few countries, and in order to gain access to some nice and the biggest clients, the most interesting clients, you need to form joint ventures in a specific country as a way to attract best clients. So some local player might suggest you form something together, and what can potentially go wrong? Quite often, these joint ventures that are formed as subsidiaries, they are subsidiaries of your holding company. They will have certain standalone IP rights at one level or few levels below your holding company. And as and when you start approaching investors with an offer to invest in your holding company, this existence of subsidiaries with, let's say, joint venture partners that have their own standalone intellectual property, that can be seen as a major, well, not a red flag, but actually, yeah, I would say yellow to red flag. So that is something that this practice, to the extent possible, should be avoided. And the exclusive rights, like ownership rights to the IP, should be kept ideally in the company that raises financing, so the holding company. Obviously, it goes without saying that it is not a great practice to have a founder who keeps certain parts of intellectual property to himself and declines to contribute it to the company, because imagine the relations between investors and founders, or just between founders, decline. So what happens next? So this person can go away and start suing the company purely for personal reasons. And surely this is not something the investor is expecting. Another thing, and here I relate to my personal experience, fairly traumatic, was when one of the portfolio companies in the fund where I was working they got a tip from the investor that they should kind of contravening the existing arrangements related to IP. They were offered to register the computer program in Russia, just literally make a filing on behalf of the Russian subsidiary and register a software program for the sake of participation in a specific project. So where the contractor, so the client was a state-owned Russian company, and they were expecting that the software would also be registered in Russia. And in order to be eligible, this company decided to file an application. And as a result thereof, there was a duality of ownership rights to a specific IP object. And once the relations became sour between investor and the company, so the company founder did not hesitate to show these files, these documents, and say that, well, you know what, you can claim whatever you want, and you can make reference to specific shareholder agreements, etc. But our company, this subsidiary company, was fully entitled to making this application and properly ensured that it is shown as a holder of exclusive rights to this specific software. And that was a situation which was all very difficult. I wouldn't say impossible, but very difficult to handle. And there were, IP litigation going on across various courts in Russia, in Moscow. So that was a big matter. And I have to say that the roots of the problem were way, like many years, they were seeded many years before, when the decision to make this application was taken. So here I'm making this
Maybe we should also get it going with the questions, because I'm thinking that
but
maybe
we are
there are
almost
some
up.
cases.
So
Okay.
basically, this is the last slide, and it is self-explanatory. I will share my presentation with the participants. So these are the things to bear in mind for your future activities. I mean, have some memo or like summary of how your company handles IP. So what you see as your intellectual property. So where is trade secret? Where is your software? Do you want to register this software? Have you made sure that your employees have properly assigned the IP rights? And obviously, founders as well. So that's self-explanatory, but I decided to put it in writing. And so this is it. This is time for Q&A.
All right, let's then probably get on just, specific cases of yours because I think that all the time the lawyers can say it depends on the general questions. So
Yes.
we have been already going through kind of Cell Kinetica case. In case anyone else wants to kind of present what IP questions do you have? Or issues or potential questions, because also we have a unique cohort where there are teams with both deep tech and AI technologies on board. So it's a kind of, double kill, I would say. So just as an example. So just please go ahead and unmute yourself, and yeah, we will be happy to interact and discuss your cases here. Just treat it as I don't know, a free mentorship. All right, I see that Miron Fini saying lots of about the comment, lots of
Okay.
about the patent, the comment.
Yeah. Okay. So I finished the demonstration, right?
Yeah, you can just close the screen and we can just get it going with to the questions. Yes, Ulysses, you have a question.
Yeah, sorry about the camera. It's a mess. So I actually registered the brand in the Benelux office, which has nothing to do with Mexico and apparently not the focus of my market right now. But at some point, I wanted to look international. So I registered the brand in the Benelux office, and nowadays I'm thinking that my most of my clients come from Latin America, but I don't know where to register the company. If the right move will be Mexico, but I'm also thinking about Tallinn, Estonia. I tried to fill out a patent in Mexico also to have a lead. I haven't got any results. I think it's a very long process. But I'm at this point that I don't know what to prioritize in order to look serious to the investors. So that will be my question. So where to open the company in terms of operations and what should I prioritize next? I'm a LMS platform, AI native LMS platform. The objective is to upscale the workforce pretty much, and
Mhm.
that's pretty much it.
Yeah, normally I would readdress this question to tax advisors because it all boils down to what the taxation of your revenues would be, and will you be able to enforce to exercise your business model. And well, sometimes you may be looking at, let's say, jurisdictions with less taxes, but then, I mean, that's what I'm talking about in relation to economic side of the matter. From a legal perspective, I guess, would be a good question actually. I would love to say it depends, of course. This is the the beloved answer to a question like that. But and what are your purposes? Like you wanna approach Latin American clients? Or you
Yes,
don't?
but yeah, that's my big advantage. But I want to be a global company. So at some point, I register in Europe because this is this figure to register in all the European Union.
Mhm.
So I thought to do that and then register to the Madrid Treaty or something like that, like worldwide. But I just find out that it's going to be very expensive. So I have to actually prioritize some markets right now. So and I guess Latam will make perfect sense. But I really don't know if since
So
my
look,
maybe yeah.
there are a few aspects to it. So I have my, how you call it, the professional the so distortion, right? So I focus on the legal issues, and let's say, are you a sole founder? Or you have some co-founders, investors, somebody else?
No, I'm a solo founder right now. So actually, in terms of patents, I'm also very curious if I should get the lead and just register a patent by myself to have a board negotiation, I don't know, advantage,
Okay.
or should that be part of my negotiation? Like, hey, we're gonna register this with the company, but I don't think I don't think it's a great idea. I'd rather prefer to register the patent on my name and then go and negotiate. But I think that's also something that I'm thinking about.
Yeah, but look, from a purely, how to say, organizational standpoint, you apply as a person, right? As a natural person.
Yes.
Then you do
Yes.
the public assignment in favor of the company. So that's okay. I mean, you can do it from your own name. to start with, that's fine. But now that you've asked about proper jurisdiction for your company, I mean, probably the question is, do you know potential big customers in a specific geography? How do they look
Yeah, it will be
companies?
Mexico. Yeah, Mexico, mainly Colombia and Spain. But the thing is that the people in terms of investment that been more interested about my company are people in Spain.
Mm-hmm.
And they're like, expecting me to register the company in Spain. So I don't so that's the sort of questions that I have right now is like, should I run the company in Mexico? Should I register in Spain? Should I register in Tallinn operating from Spain? So because I know Spain has big taxation
No,
system.
frankly speaking, taxation would be your question number one.
Yeah.
Well, inevitably, you will start employing people uh, for your office, like a team, etc. So, once again, it's going to be either employment or some third-party contractors, up to you, of course. But then you really realize that the contractual relations you have with your employees kind of is stronger, right? So they
Yeah.
stay with you for a longer period. But having said that, you will need to comply with employment protection legislation, so which can be an issue because you will have to, register certain funds in case you will need to fire these people, and that obviously causes uh, it might cause you headache, etc. So
Yeah.
that's that's a tricky question, really. What I would recommend you do, like as a specific exercise, is to take a look at all the tax exemptions that various countries offer to startups in AI sphere or in the sphere where you operate, because these days there's definitely a competition among jurisdictions, and
Yes.
every country in European Union would be up for offering some um, assistance to companies like yours in a form of grants, for instance, or
Yeah.
let's say subsidized company registration. So that could be worth exploring because you might save up to like a few €100,000 on that, which
All
is
right. Yeah.
good. Yeah.
Yeah. I'll do that. Thank you, Vasily.
I guess we need a, week 9 on taxation and on tax advisory. I'm
Yes,
just
please.
joking in the program, but also tax advisory is. I mean, I know only regarding Europe. It's like on every single little country there are certain benefits, certain trade-offs, certain drawbacks. So yeah, we need another program on that. But jokes aside. Thank you so much for the question. Any more comments or questions or maybe personal cases that we can kind of go through now because we still have the time and yeah, we still have the brains here. I would say not who are not just saying it depends. That's also a very valuable thing. All right. So, yep, someone unmuted. All right. Yeah, I see. Miron, you are already with a camera. Probably you can have some comments or you have some questions.
Yeah, I have a few questions. Like,
Mhm.
I understand that nowadays patent it's just more like an achievement and not something that protects your invention because there are so many ways of building something. But actually my question is like, how can I protect the idea of the software side that we are building, for example? Because
Idea.
for example, we are building like a live operating system, and
Mhm.
this means simple and straightforward, bring everything we do digitally into one platform, and then let AI kind of analyze it, and not just AI, because we need also human oversight, but kind of bring everything you do digitally and then make it in a way that makes sense. How can we patent this or at least protect the whole idea in the way where maybe if someone else tries to copy the same methods we use, or not methods, but the same idea.
No, ideas, okay, so they're not patentable
Yeah,
for sure. So this is a
I know.
key rule. Yeah, of course. But what you can do is you can keep this information to yourself. So you will not disclose your idea to anyone else, but for your team of co-founders. You will keep it confidential, like the essence of the idea. Like frankly speaking, idea is obviously it's too vague to constitute a trade secret. But having said that, try thinking, would it give you any value if you just keep it confidential to you and to your team? And you will
I
practice
mean,
this idea. You won't be able to stop others from discovering this idea at some point in time, for sure. But at least if you keep it confidential and if you will ask others to keep it confidential, by way of signing NDAs. That's the way you can at least ensure that nobody else will find out about this idea. Does it make sense? Because truth is that you won't be able to prevent others from practicing it, for sure.
yeah, exactly.
But if you keep it confidential, then at least hopefully you won't give others advice. You won't give others. You won't leak this information to others so that others start same thing as you're doing. Sorry, I'm sorry. I might be a little bit not being entirely clear, but I try to.
No, I understand. I understand what you say. It's more like in my mind, the idea is super simple, and I try to find a solution similar, and it's all based on software. And I'm more like thinking, how can I kind of protect it to the point where big players like Google's, OpenAI, or someone else don't
Anytime you go
replicate
to
it.
anytime you go to any negotiation, well, if you are disciplined enough, so please sign NDAs and say, well, look, I want to discuss one thing with you, but I want to keep it. I don't want you to tell about it to any third party because, well, this idea, it has value even now, even though I haven't implemented it. I want you not to dilute the value of this idea by circulating
Okay.
all over the place. It does sound, uh, not to say strange, but like maybe people will look at you with a smile and say, well, look at him. He hasn't done anything but already asked you to sign an NDA. But normally that's the way you would protect what you have at an early stage before you have
And and if we did like everything, like if we have uh, all the platform functioning in terms of code and all of this, is that helpful in a world where, because I also feel very strongly the same. Patents nowadays are kind of an obsolete function, right?
Yep.
20, 30 years ago, it was relevant because we were not so many founders. But nowadays, we are all taking the founder road, and we are able to build so many great products like in the batch we have nowadays, you know?
No, it's not only because of startups. In fact, uh, it's just in the nature of um, the way the patent works. So you have to define your field, define what makes your
Okay.
solution unique. And truth is that it's not that you these days you can patent, let's say, a razor blade with four blades, like or something like that. So every item you can feel or appreciate, see somewhere, like let's say the new ones, they would be a combination of at least dozens, maybe
5-4, yeah,
50,
exactly.
no, 50, 100, maybe 50, maybe 100, maybe 120 patterns just to make sure you can produce a new generation, let's say, Mach 3 blade. I'm not being entirely
Yeah.
new
No,
and
I
fresh,
understand.
but
I understand.
took,
I
it took
understand.
them it took them 50 patents, 50, 50, to protect this new item, like 20, how many? 25 years ago. So, and in computer sphere, the density, the number of patents is way bigger because Mach 3 is a very, how to say, old school consumer goods area, but programs, and not really programs, but like algorithms and the way the algorithms work in some hardware. So there are so many patented um, algorithms that it's virtually impossible to claim anything meaningful these days. So that's a big problem.
Yeah.
I mean, that's a
Okay.
systemic problem.
Okay, thanks for your answer. And also for the entire presentation.
Oh, thank you, thank you.
Well, not so optimistic though, but realistic regarding the protection measures. All right. Any more questions from the founders here, or maybe some comments, maybe something opposing? I see that QBDC already wanted to ask about patents and got to learn everything needed for the decision making process, hopefully. All right, let's wait for a little bit in case you have any questions or comments.
Yeah, may I feel a pause
Sure.
if I have time? So first, thanks a lot, Vasily, again for nice introduction to this topic. And I just want to clarify. I have 3 questions if I have time. But first clarification: am I right that your decreased value of patent now is because niche, which can describe one pattern, is just decreasing because we go to this multi-space environment and yeah. Yes. So we have this like multi-space dimension, and we multi-dimensional space, and we just patent, and so each one patent covers little niche.
Exactly.
And one step left, one step right, we're out of patent. So there is, okay,
exactly.
That's good visualization for me, at least, to understand why this value is changing.
Inscription.
Yeah. May I have a question? So you recommended that when a company starts to grow, of course, co-founders should take care of a core algorithm, a trade secret by some kind of confidentiality. And so what exactly you can propose? For example, now we are 5 founders in Cellkinetica, and we start to find people, legal support, financial support, and very often that's our friends or friends of friends, colleagues who are able to work for free, to help, etc. So, but it seems that we have to sign either NDA or something with all new people beyond founders. Yes, that's simply speaking. So we have to do something. We have to make a separation between founders, we know everything, and all other people, they don't know everything, and we do some steps. We do something to prevent knowledge leak. Yes.
Yeah, that's correct. But I need to know as follows: that you need to understand more or less in advance if this person will have access to trade secrets and know-how. Because look, if you are asking your CPA or like public chart like accountant, right, to help you with filing a tax report for the, let's say, last year, that doesn't necessarily mean they are. I mean, probably yes, you might want to sign an NDA because you don't want this person to to disclose financial data about your company, but that's not really IP related. It's a separate let's say headache or issue to bear in mind. But you just need to understand if a specific, let's say you want to hire a person that would support your chief technology officer. In that case, I would definitely ask for, recommend signing NDA at least. And obviously, with passage of time, if you expect this person to contribute to, creation of intellectual property, like this person will single-handedly or as part of a bigger team, let's say improve your like system architecture. I don't know, like imagine some processes. I dare to say that this person, by doing so, have contributed to your know-how, and he has to formally execute IP assignment. Like, I mean, it may sound a little bit strange, but this will facilitate your life further on as you go.
Okay, thanks a lot. Nice, I got it. May I have one last question from my side, Irina and Vasily? Yeah, very, very, very technical. So it's normally when we are like emerging startups, we have no legal advisors. So we go to Y Combinator webpage, download some template and sign it, and we say, okay, fine, or we ask Perplexity. Would you recommend to have a real advisor, let's say with 0.01 share somehow? So basic things we can do with Y Combinator templates and with Perplexity, but sometimes we don't know what is basic, what is not. So I'm in Switzerland, and from one canton to another, we have different rules. And of course, Y Combinator will give me very general purpose solution, but not in Canton Vaud or whatever. So would you recommend to have a legal advisor? And if yes, are you available to be a remote legal advisor if I find somebody in Switzerland and he will be like 10% with me, but with difficult, he can be like from university yesterday, no experience, but some education, and you can be like remote senior advisor, theoretically.
I sometimes do it. Like it's not unheard of for me. So there is such role these days. It's becoming more and more popular. It says fractional chief legal officer, which means that a specific person is supporting a number of companies as they have need to engage a specific lawyer for some complex task. Let's say you are having some complex negotiations with some major IT corporation, some giant, and there's no way you can understand what they are asking you to sign. And yeah, I mean that's something I do on a regular basis. And like myself, or let's say some people that I know, they would have some sort of a subscription, and they would make some guess, like how much time would be needed for a specific task, and just stick to this subscription. And it's up to you how you are planning to utilize the time of these specialists. But obviously, if you have some mundane tasks, then obviously, Y Combinator page is helpful. You have some, yeah, I mean, use with care, obviously. I mean, Y Combinator is good, but they don't have that many templates, to be honest. So they only have, the ones for investments. But let's say they don't give you anything related to, let's say, licensing or let's say master service agreements or something like that. So for those purposes, you definitely would need somebody who is accustomed, who understands what the essence of these documents is.
Yeah. Yes, I agree. And the problem with legal issues for me, for biologist and bioinformatician and bioengineer, that it's good to know rules or laws before, not after. And when I come to new part, I have no idea if it's difficult or not. So I do default Perplexity plus Y Combinator. And after 1 year after, I can realize, oh, it was not simple step. And I did something wrong. So yeah, so it's good to know laws before, not after. That's why I ask you. Thanks a lot.
That's exactly what I had during my presentation is that
yes,
it's so easy, like so straightforward to have something in writing with your co-founder, like IP assignment. I mean, I can send it to you after this conference, and it will take like 15 minutes to have it signed all together with an introduction by myself. But imagine there's a very big number of people who I talk to, who I respect as founders greatly. And they come to me and tell me that, you know what, we should have settled that matter right at the beginning. But now that I'm selling my business, I have to come to my co-founder and tell him, sign a release of claims. And that guy is unwilling to do so because he can oppose to it. And now he can claim, all right, well, why don't you give me, let's say, extra percentage of proceeds from the sale of business. And that guy is like, I'm so afraid of offering him to sign anything because I'm afraid he will ask for money. So, and once again, like settling it beforehand is super easy. It's just really straightforward. Doing it afterwards, yeah, that's complicated.
Thanks a lot again. Thank you.
All right. I think that with this being said, I have actually 3 points to wrap it all up. First of all, of course, it's the feedback forum for the founders. So can you please just click and fill it in? The second is the question, the final question to Vasily, since it's the last workshop of the year. What could be the home task home task, like, as in inverted commas, just to think about founders checklist, just maybe 3 points or 1 point or something really easy, because we will all get to know through your slides regarding the documents. So yeah, let it be that.
My last slide was related
Yes,
to
but
the things
it's
you should have in place. I think that probably it may make sense to look at what you have at the moment, like what. So look, you have some universe of ideas that have been, expressed in writing, or say in code, or through other means, through some processes. You have it in your head, you may have it in writing, etc. Just the general, maybe a recommendation would be to think of categorizing it, like what you have at the moment, and let's say this should be kept as a trade secret because this has value, and this value will be diluted if it becomes public. Or let's say this solution that I've come out, like that I've devised, is so revolutionary, so unique that maybe 10% likelihood I might think of patenting it because it's so groundbreaking. Or you have some bits of code that you realize you want to reserve rights to it, you want to register it. So my advice, my homework would be at least to start thinking about how you can categorize all those ideas you have. Sorry not to be straightforward, but
I think it's good for the strategic reflection. Let's put it like that, from the legal standpoint.
Because just don't think about it as a world of some, uncategorized ideas, because they can be categorized, and it's good to make this exercise before talking to an investor. And the investors definitely will be impressed if you show them that, look, we treat our business seriously. It's not that we are, paying crypto to some third-party developer somewhere. He sends us something via Telegram, or like deposes it on some Google Drive, and we access it, and that's it, and that guy vanished, and we have this code, and then we do something. So it's just think about all you have and try to categorize it.
Perfect. I think it's a good way forward and a good wrap up of the session. And yeah, the third point is to thank everyone and thank Vasily for sharing the experience and also the tips and the tricks. And I think that this recording will be, the founders will re-listen and again, because there were so many hidden points in there. And thank you so much, founders, for your participation, questions, and comments. And well, with this, we are definitely finishing it all up, a very nice note. week 6, going on a winter break. I mean, please don't forget to go with your mentors for one-to-one communication before that, before Christmas. But definitely, and also you know where to find us if you have any questions. But it's good to finish up group activities and go on individual tracks. And see you all in the new year in 2026. Happy holidays, happy winter break. Yeah, well, with this being said, let's wrap it all up. Thank you so much for participating.
Very much. Bye bye.
Thank you.
Bye.